Okay, it is June 24th at 5:37. I'm going to call the meeting to order.
Okay, I'm going to take roll for tonight. We have Commissioner Linda Allen. Present. Commissioner Cummins.
Here.
Commissioner Eddie Mitchell is noted as absent. Commissioner Harrell.
Here. Report on posting of the agenda.
The agenda was posted on Friday, June 20th at 7:31 p.m.
Okay, so communications by members of the public for items not on the agenda. Public comment by members of the public on items not on the agenda, but within the subject matter jurisdiction of the Personnel Commission. Please limit your comments to 3 minutes. This portion of the meeting is reserved for persons desiring to address the commission on matters not on the agenda. The law does not permit the commission action or extended discussion of any item not on the agenda except under special circumstances. If commission action is requested, the commission may place the matter on a future agenda. Next item is the approval of the minutes.
And just for the record, we have no public comment. There's no members of the public in attendance at our meeting this evening, and we have no public comment.
Okay, so the next item is approval of the minutes for the meeting of April 28th, 2025.
And the minutes are included in your packets, and anyone can note anything if we have any corrections that need to be made. Otherwise, even if you weren't present, you can still vote.
Make a motion to approve the minutes from the April 28th, 2025 meeting.
I second.
Favor?
Aye.
Aye.
Okay, the minutes are passed on a 3-0 vote. Okay, so now we are moving on to our Personnel Commission training. And this evening we have Gage Dungy with us, and he is an attorney with the firm of Liebert Cassidy Whitmore. And this firm specializes in public sector employment law. And so Gage has prepared a PowerPoint presentation for us this evening, going over our hearing procedures. He's gone through all of our rules and regulations related to both disciplinary appeal hearings and grievance appeal hearings. And he is going to walk us through this training to keep you comfortable with this process should there be a situation that presents itself where the commission needed to conduct a hearing. We always want you to be ready to perform that part of your job. So Gage, I'm going to hand it over to you. Thank you for being here. We appreciate you.
Great. Thanks, Leanne. Hopefully, can you guys all hear me okay, I hope?
Yes.
Great. Here, let me, oh, how do I get the PowerPoint to share? It says sharing.
Okay, let me give you permissions.
All right.
Do you have it there?
Let's try it again. Oh, it's, yeah, here we go. Okay, give me 1 sec. All right, is that showing up?
It says it's starting, so
There we go.
there it goes. Sometimes there's a
Okay.
little lag.
Gotcha. All right.
And we have the slides in printout format to follow along with your presentation.
Okay, perfect. Well, good evening. Pleasure to see you guys all. And as noted here, and as Leanne mentioned, we're going to be talking about post-disciplinary appeals and grievances in the city's personnel system. So we kind of pegged about a roughly 1 hour training. We kind of play it by ear. I have about 33 slides to kind of go through. As we go along, please feel free to ask questions. The goal of this kind of training is to give you, especially we're going to focus mostly on the post-disciplinary appeal part, because that's probably the more common area that a hearing may come before your body as the Personnel Commission of the city. But just to kind of give you a background of kind of what that means, how disciplinary actions work at the city, and kind of what your role would be as a Personnel Commission to oversee those hearings when they come up. So I'm going to give you an overview of that. One thing I will point out off the bat is anytime that, and my understanding, and Leah, correct me if I'm wrong, but anytime that the city does have a matter that goes before the Personnel Commission and you guys are overseeing and conducting a hearing, usually a separate attorney is assigned to help assist and guide you. I say that because you're not on your own. So while we're giving you an overview of this, typically when a hearing does take place or occur, you guys will have an attorney assigned to you to help, kind of guide you through how the process of the hearing will go, help to assist you in drafting the finding of the Personnel Commission based on the results of the hearing. And so you'll be in, at least in good shape on that. So I do mention that during the training a little bit, but I just want to give you a quick heads up on that. So real quick about myself, just as Leanne mentioned, I'm a partner at the law firm of Liebert Cassidy Whitmore. I'm actually based out of their Sacramento office. Been an attorney now for, it blows my mind, 22 years. All I've ever done is labor and employment law. And almost the whole time of that 22 years, almost the full amount of it has been representing public sector agencies, especially cities, counties, special districts. So I'm very familiar with public employment issues that come up, working through disciplinary type issues. And it's important to understand because I think one thing that for a lot of people that comes is, and it can come from you, if you work in the private sector, for example, you may see employment type actions viewed in a different way. For example, many employees in the private sector are at will, if you've ever heard that phrase, which means that their employment is at the will of the employer or the employee and can be terminated at any time. Major difference here in public sector based on our rules that we have as a city, most of our employees are for cause, which means that when we have a disciplinary type action, we have to be able to establish was there just cause based on our rules and what those are. And I'll kind of go into that to justify that process as well. Then based on constitutional principles under the 14th Amendment, I know this kind of turns into a civics class almost a little bit. We have what's called due process rights. Sometimes you hear them referred to as Skelly rights, where we also have an appeal process. And that post-disciplinary appeal in the city system for a number of employees does go through your commission, which is the advisory to the city administrator as well as to the city council. So that's kind of where your role comes in. And so as we go through, I'm going to kind of explain, those purposes and how that comes into play. At the very end, I'll also talk about grievances. My understanding is that you guys, as a personnel commission, don't have many grievances get to the level of an appeal that goes before you, but it can happen. It's part of the city's rules. But a grievance, in contrast to a discipline, is really focused on we have a contractual dispute, looking at the personnel rules, memorandums of understanding, and then this is a matter that then there's a dispute over how the rules applied or if it wasn't applied in a correct fashion, and so that's trying to address the contractual issue with that. So that's kind of the overall, role of the Personnel Commission in terms of what you do. So as I go here, our next slide, your role as the Personnel Commission comes from your city charter. And the part that we're focused on here, as it notes, is really subsection B. While you as the Personnel Commission has the power and duty, and you work within subsection A is more of an advisory capacity on classification plans and rules. This part we're going to talk about this evening is to hear appeals of an officer or employee who has that regular full-time status that makes them a for-cause employee in any office position or employment in the competitive service that pertains to suspension, demotion, dismissal, or other disciplinary action provided for in the human resources rules and regulations and the memorandums of understanding, or sometimes we call the MOUs. So that's your kind of initial role. That's where you come into play. What that means is on that subsection B, you do potentially have a role to hear disciplinary appeals. That it's advisory to the city administrator, the city council, as I noted. That disciplinary appeal is actually what we call an evidentiary hearing. And I'm going to kind of go through what that means. A good way to think of an evidentiary hearing is like a mini trial. It really is, both sides have to produce evidence. The burden's going to be on the city to say we established discipline. We feel it's justified for these reasons. The employee who's appealing says, no, it's not, or they're going to have their argument. You can call witnesses, produce evidence, and then you as a commission have to review that to determine that is the discipline justified? Can it be something that's reduced to a lower discipline or perhaps even thrown out if there's not sufficient evidence, and that's going to be vested in you in an advisory capacity. So that's kind of where your role as a personnel commission comes into play. So when we talk about post-disciplinary appeals, I'm going to start off by kind of explaining how discipline works at the city and in the context of, kind of public employee discipline as well. So typically when you hear about disciplinary action, and I use the terms minor discipline, and then we have more significant discipline. A minor discipline would be a written reprimand, for example. And a written reprimand is just that. It's a piece of paper. It says you did something wrong, you violated a rule, don't do it again. There's no impact on your job. There's no impact necessarily on your wages. And so we consider it more of a minor discipline, even though it goes in your record. And obviously, if you engage in further disciplinary action, that could be used to justify taking a more significant discipline, which is the next one here. And I put in parentheses due process rights, and I'll explain that in just a moment. Unpaid suspension, demotion, reduction in pay, termination. If you look at all four of those disciplinary actions, the one key thing that makes them quote unquote significant, which invokes due process rights, is there is something at stake where you lose money. If you termination, you lose your job. So you lose your wages that way. Unpaid suspension, or reduction in pay, you're gonna lose wages as part of a disciplinary action. Demotion, you lose wages because you're gonna go to a lower paid position. And so why that involves due process, and you hear this phrase due process, where does that come from? It comes from the 14th Amendment to the United States Constitution, which says that government cannot deprive a person of life, liberty, or property without the due process of the laws. And actually, when you hear life, liberty, or property, and once again, going to like a civics class, we're focused on property. And sometimes you hear the phrase a property interest. And why that's important is when we have employees at the city who are for cause employees, and I'll explain that in a second, but that means that we can only discipline them based on cause. Otherwise, they have an expectation of continued employment, meaning that they come to the city, they work every day, they expect to have a job to maintain that job. And the only way that we can take away that job is based on cause. And so if we as government, because we're an arm of government as a city, as a municipal agency, that's where the 14th Amendment applies, we have to provide due process of the laws for that reason. And so that's kind of where that part comes into play. When I say for cause employees, I mentioned a few moments ago, this is in contrast to someone who's at will, very more common in the private sector. Although we may have some positions at the city, usually they'd be higher level positions or perhaps even temporary positions that are at will. At will is the default standard under California law for employment. And that's where, a person's hired and they work out the will of the employer or the employee. The employee can leave at any time or the employer can separate their employment at any time. In contrast, though, when we talk about the concept of a for-cause employee, this is more common in the public sector and it's all rule-based, and that's what the city's rules provide for, where a person's hired on to usually a regular, let's say, full-time position. They have a probationary period they serve, which is done in a kind of at-will capacity where we can let you go at any time during the probationary period. But once you pass that probationary period, then you become, sometimes you'll use the phrase regular employee or ongoing or permanent employee. And that's where those for cause rights come into play. So if we were to discipline you, deprive you, take your property away, which would be your wages, in that circumstance, that's where due process rights come in. Sometimes you also hear this referred to in the context of the being Skelly rights. Skelly is a case, a California Supreme Court case that kind of interprets how the due process rights apply. It's called Skelly versus the state of California. If you ever want to think about what Skelly is all about, it's about actually a dentist who worked for the state, or there's either a doctor or a dentist, I can't remember, but he was in the medical profession, state employee, and he had a drinking problem. I always think of it as the drunk doctor. In essence, Skelly would leave work frequently, had many absences. One day he claimed he was sick and that he needed to leave and go home. His supervisor, this is in the 70s, by the way, got suspicious and went down the street to the local bar and found him sitting there doing shots where he claimed he was waiting for his wife. He was fired on the spot, but he wasn't given an opportunity to respond. And so based on that, in this case, Skelly, the California Supreme Court said, no, if you're a for-cause employee, if you have those due process rights require us to be able to provide you, with an overview of what your actual action is, what the cause is, give you an opportunity to respond to it. And then finally, you also have this post-disciplinary evidentiary hearing. So actually going to this next slide, that's kind of what that goes through. So when we discipline someone based on the concepts of what Skelly has, these are kind of the steps that the city has to take. When we hit number 5, that's where you guys come in terms of that evidentiary hearing as the Personnel Commission. So first of all, we have to do an investigation or look into it. In essence, we have to create or establish what the cause is, what the violation of the rule is, put together a proposed notice of intent to discipline, outlines the disciplinary action, outlines what the cause is, outlines what the so-called, use the word evidence that justifies why we're taking that action. Then the person has a right to a pre-disciplinary response that would be usually done, perhaps with the department head or others, the person imposing the discipline. And the purpose of that's to respond to before it's imposed. And it also gives the city an opportunity to get that additional information. They may modify the discipline or pull it as well. Once the written final notice of discipline takes place, and this is once again on those more significant disciplinary actions, unpaid suspension, demotion, reduction in pay, termination, then that is imposed, that's final. But the second part of due process rights is this post-disciplinary evidentiary hearing. That's where your role as the Personnel Commission comes into play. If an employee requests that, then that evidentiary hearing is held before the Personnel Commission. We put on the case. It's before a neutral body. You're not involved in the previous disciplinary action up to that point. And then your role is to administer the evidentiary hearing and make a finding that's advisory to the city administrator or the city council. Now, that last number 6 part is even based on the outcome of the evidentiary hearing or the final decision of the city administrator or the city council based on the city's rules, there is the ability under most circumstances for judicial review. Someone could file what's called a writ of mandate to the Superior Court, saying that that was improperly administered, and they'd have to go through that process. So there's a lot of checks and balances, I guess, is the way, if you want to think about this, about how disciplinary action takes place. But your role as the Personnel Commission, and a very, very important role, is to handle those evidentiary hearings, post-disciplinary evidentiary hearings when they come through, unless we've agreed otherwise, for them to go to things like binding arbitration or something along those lines. So when we look at disciplinary action, and this going back to that Skelly versus State Personnel Board case I was mentioning, this is kind of what the California Supreme Court noted is what we look at as to what's appropriate from a for-cause standpoint. As it notes here, the overriding consideration in these cases is the extent to which the employee's conduct resulted in, or if repeated, is likely to result in harm to the public service. And so disciplinary action can vary greatly. We can have more very serious incidents of disciplinary action where one incident is sufficient, for example, for us to recommend termination, to have the cause to do that. If we have an employee, for example, who engages in the theft in the workplace, or sometimes we see dishonesty, let's say workplace violence, sexual harassment of a criminal nature, we're not going to go through the steps of disciplinary action, just give them a written reprimand, don't do it again. We may have to go to a more serious action because it's the harm to the public service, harm to the employees, harm to others that are there. On the other hand, though, if we look at other types of disciplinary actions, they may vary greatly. Performance-based issues is a great one where we oftentimes will go through the different steps of disciplinary action. And I guess when I say steps, one of the phrases you may hear a lot, you may hear the phrase progressive discipline. Progressive discipline is a very common way to kind of say, well, we start off perhaps with a more informal counseling. Then it gets to that written reprimand, the minor discipline we talked about. Then we may start to look at an unpaid suspension or even a demotion, and finally termination. And all those are going to vary depending on the nature of what took place, what the actions are, what it is. So for a great example, if we have someone who we found out embezzled from the city, they work in the finance department, and it turns out they were skimming utility fee payments, odds are we're going to go to a termination right away, as well as probably call the local law enforcement, the district attorney's office, to seek a criminal prosecution in that way, because that's not something we're going to tolerate. On the other hand, let's say we have an employee who, from a performance standpoint, has multiple tardiness. They come to work late, 10, 15, 30 minutes, sometimes maybe an hour late every other week or so. In those kind of situations, when that occurs, we're probably going to start at a lower level of discipline, maybe a counseling. It's important that, if you're late to work, we don't get the work done, you need to get here on time. If they continue to do that, we may go to another step in the progressive discipline process, and further up all the way to termination, for example. I once had I'm thinking about a case for another city client I worked with several years back where we had an employee from a performance standpoint, who for several years had been in this position, but yet probably did not have the skill set to do things. And she was a finance clerk, had overages and underages several times. And actually it took several different disciplinary actions, performance evals, other things, until it finally got to a termination of employment that was appropriate from a for-cause standpoint. So all these are going to depend on the underlying facts of the issues, and what that comes to. But when we look at that level of penalty, though, too, these are kind of the three main kind of, I guess I would say, earmarks that we kind of aim at, cornerstones of that disciplinary action. Are there aggravating factors? that can apply, mitigating factors, and then also the objectivity of the decision maker. Probably more importantly is when I think of the objectivity, are we being objectivity in terms of the application of the rule? Do we apply that more consistently or not? So from an aggravating factor, for example, is the person in a higher level position, like a supervisory circumstance where we may hold them to a higher standard that could, lead towards a higher level of disciplinary action if they're engaging in misconduct or bad behavior. Have they engaged in similar misconduct where we have multiple incidents of disciplinary action leading up to this of a similar nature, or even just overall of just disciplinary action, meaning that we have a person who's not wanting to follow our rules? Those can be aggravating factors. Are they aware of the issue? Have they been on notice? This is a rule that we're going to enforce, and yet they continue to not do so. Those are all things that are what I would call aggravating type factors. A mitigating factor is something where it would actually lessen the level of penalty potentially. Sometimes mitigating factors, for example, can be a number of things. The employee's length of service and prior good evaluations, lack of previous disciplinary action, for example. Those would all be examples of mitigating factors. And why that's important is sometimes we may actually have a situation where the level of penalty in the disciplinary action could vary for a similar action where you have an employee who's only been here for, let's just say, barely passed their probation, 1 year, versus someone who's been here for 20 years. And the 1-year employee, engages in a certain level of misconduct versus the 20-year employee who has a clean record, has never done anything previously. We may view that differently looking at the aggravating versus the mitigating factors. The last part is when we say the objectivity of the decision maker, so to speak, kind of the idea here is we're not focused on, emotion, frustration, bias, favoritism, other types of things. Hopefully, and this is where you're going to see arguments like my supervisor's out to get me. That's why I'm being disciplined, for example. Rather, we're looking at how has the rule been applied? Has it been applied consistently or not? And if it's not done in a more objective fashion, that can undermine the overall ability of that disciplinary action. I once had a case for a city client. This actually was a case involved a labor relations issue where it was the union president of one of their bargaining units had misused a union time bank, and they actually imposed I think it was a 2-week unpaid suspension on him. And it technically was a violation of the rules. He didn't use it properly. Now, one of the kind of objectivity issues that I think came into play here is it turned out other bargaining units had used the time bank in the same way and yet never had been disciplined. Yet this one guy all of a sudden gets a 2-week unpaid suspension. Does it look like we're applying our rule consistently? Does it look like that's being objective in terms of what the issue is? That was a problem for that client in that case. That was a matter that, from the disciplinary standpoint, actually went to what's called the Public Employment Relations Board, who oversees labor relations, and they actually threw out his disciplinary action. It's kind of a little separate thing. But I think it's a great example of, I think in that case, and one of the problems that for my city client at the time was, when I asked them that question too, how come we never discipline anyone else? They didn't have a good answer for me. And I know that they didn't like this union president. He pushed their buttons, so to speak. Those kinds of things, though, undermine us having a more objective fashion in terms of trying to impose our rules uniformly. And so those are also things that I think we're going to, consider and keep in mind. One last one I don't have on here, but I also think is also a factor that can impact the level of penalty is that are there any other legal issues or concerns that relate to the underlying disciplinary action that can involve protected activity or other things that relate to what the person did? Even though we can articulate there may be a violation of our rules, that could also impact our ability to take disciplinary action in those circumstances. But when we look at this level of penalty overall, some of the things that are looked at, did the employee have notice of the rule and the penalty for violating it? For example, if we have a situation where, yes, we have a tardiness rule, but it turns out that over the last, several years, no one's enforced it. People come to work late all the time. And then all of a sudden we just, give a more serious discipline to one employee for that reason. That may not match having the employee on notice, making sure they're aware of it, making sure it's, there's people were made aware that we do have this rule, we're going to enforce it, those kinds of issues. Does the rule serve a useful purpose? Mostly, if we can point to something in our rules that are a cause of action or something, we hopefully should be in a stronger situation to do that. If we can't articulate what the action is, or I should even say better yet, I've seen situations where if we don't have a rule we can point to, even though the underlying behavior we may feel is inappropriate or constitutes misconduct, but we can't find a rule to address it, that's going to be a problem for us to take an action on. I once had a city client that they had a matter where it was actually a supervisor in their public works department who was going to their subordinates and trying to solicit drugs to buy. I think it was marijuana to buy at the time, and which is not not something you want to have happen in the workplace. I mean, I know our laws on marijuana have been more loose, and this is probably a little bit at a different time period. But what I would say was very interesting is when I'm working with the client, it turned out they did not really have a very strong drug and alcohol policy that really addressed this type of issue. It made it very, very difficult to take a disciplinary action. So what's the rule we're looking to do that? Can the rule be followed? Is the rule clear? Does it have vague, undefined terms? And has the rule been applied uniformly in the past? As I mentioned, that goes to that consistency, that objectivity of the level of penalty as well. But when we get to the final notice of discipline, this is what you guys will be reviewing as a commission on appeal. The purpose of that notice of discipline is we're going to memorialize the position that's taken by, or we basically take what the notice of proposed discipline is. They have the Skelly meeting, or perhaps they don't. And then if we do have a Skelly meeting where the employee does make a response, that should be incorporated in there. And to give you an example of what that would be, let's say we have a notice of intent to terminate someone because they engaged in inappropriate sexual harassment towards a coworker. And we did our investigation. It was sustained. We applied that. We point out this is inappropriate behavior. Person shouldn't be allowed to do that. They come in for a Skelly meeting. A very, very common circumstance could be that, hey, I don't have any previous discipline. I acknowledge that what I did was inappropriate. I still think I can have a serve a purpose and be able to work here. And then I ask that you instead reduce it to an unpaid suspension and let me keep my job. Now, if we still think the severity of the sexual harassment, being the city does, and they say that's not sufficient, they would incorporate that in the notice of discipline. It would note that we had a Skelly meeting. While you noted that you've been here for several years and you have had a clean disciplinary record and should get a lower disciplinary action, the nature of your circumstances of sexual harassment can't be tolerated in the workplace, and we see no reason not to take action otherwise, for example. So that'd be noted there. But then beyond that, though, it's going to also advise the employee of their post-discipline appeal rights, which then would go before you as the Personnel Commission. And that's where they can make that initial appeal to you. So that's going to be the notice of discipline, so to speak. That would be the underlying document that when an appeal comes to the Personnel Commission, you're going to be reviewing the facts that are in that document and as presented in the evidentiary hearing that would be conducted before your commission. So when you as a body, as the Personnel Commission, when you're going to be looking to oversee an administrative appeal here, to hold this evidentiary hearing, one of the key tenets of due process is that this be done before a non-biased hearing officer or body. And so why that's important from your standpoint, and by default, you guys should be in a very good position here because you would not have been involved in the underlying discipline. You didn't impose it. This is now just coming before you. So it's kind of like you have a fresh set of eyes on it. And you're coming from a neutral standpoint to oversee this and decide and take your action. But one thing that's very important, though, is if there is any concern of bias that you may have, it's probably a good idea to potentially disclose those matters or at least be able to raise those things if they may impact your ability to take an action as a personnel commissioner or as at least one member of the commission. Bias can come in a lot of ways. Do you know either of the parties? I would say mere knowledge of someone's not going to necessarily disqualify you or create bias, but if it turns out, like especially if there's a closer relationship, person's a family friend or family member, even for that matter, that's something where it's probably less appropriate for you to be part of it. Or if you know any of the witnesses, same thing, where there's the nature of your personal relationship could cloud your ability to serve as in a neutral capacity. If for some reason you have personal knowledge of the events at issue or you were involved in the underlying events, if there was a disciplinary action that took place because a employee made an inappropriate comment to one of the commissioners that are here today, and we took discipline for that. Well, you should not be the person overseeing that appeal because you obviously wouldn't be in a neutral position. You were the victim there. That's a very kind of common example of that. So I would just note if that ever comes up where from the outset, you see whoever's involved in the disciplinary action or a witness, or you think that's going to create a concern, it's something that you can address with the attorney, for example, that'd be assigned to the Personnel Commission, and it may be something to look at if it's grounds for recusing yourself. These are not, I would point out they're case by case by what you know. it's very possible we know a lot of different people. You know, they're employees at the city. The fact you know them doesn't necessarily mean you're not biased. It's more the fact of what the extent of that relationship is that could create the bias. So just something to kind of keep in mind there. Now, in terms of the actual, appeal itself, once the employee gets the notice of final discipline I mentioned a moment ago, they would then make a timely request for a post-disciplinary appeal process. That's typically going to be 10 calendar days after they receive that final notice of discipline. Sometimes the city can grant short or reasonable extensions for good cause, but we have a timeline because we're trying to see if you want to appeal it, you have to let us know. You can't just come back, for example, 2 months later and say, now I want to appeal it. We want to have that kind of time frame so we can move things along. One thing that's interesting that I should point out too, when I say it's a final disciplinary action they're appealing from, the city actually imposes that disciplinary action. So if we're talking about an unpaid suspension, and there's an unpaid suspension of a 1 week unpaid suspension, the city would then impose that suspension. The person can still appeal it. If it turns out that we overturn that on appeal or we reduce it to a lower discipline, we would just make the employee whole. If we terminated someone, they will be terminated from the city. And if the Personnel Commission decided that the termination was too severe and should be a lesser discipline, like an unpaid suspension, or even to throw out the whole disciplinary action, then what the result of that from a remedy is we would reinstate the employee and provide them back pay to make them whole as if they were never terminated, for example. But the final discipline is enacted even though this pending appeal may take place. So I note that because sometimes I don't want to give the impression that, like, if we have a termination that the person's on like paid admin leave while we're waiting for the appeal to happen. No, that's final. It just means that we have to provide a remedy if the commission chooses, and that's advisory to the city administrator, city council, and it's approved to bring the person back, for example. In terms of the hearing itself, the rules note that it should be scheduled between 20 to 60 days from the date of the employee's appeal, and continuances for good cause are shown. So typically speaking, the goal here is to try to have a hearing that's done in a timely fashion. Now, sometimes depending on the nature of the actual disciplinary action, you may see it could be both the city, and or the employee actually asking for more time so they can prepare their case or put evidence together, perhaps get witnesses together. That's why sometimes we do see continuances in that regard. Now, even though as the Personnel Commission does oversee these matters from a Brown Act type standpoint, the holding of the hearing typically can be done in a closed session private matter unless the employee requests that the matter be done in public. There is a part of the Brown Act that allows employees anytime that a body is going to oversee charges or complaints, which is kind of what this hearing would be from an evidentiary standpoint, they can actually request to have that hearing be done in public. We have to provide them an opportunity to make that request. Most employees do not do that for good reason. You don't want to air your, for lack of a better term, you don't usually see employees air their dirty laundry out there in public. I do know one city client I worked with, this was probably about 10 years ago, that they had a matter that went to their city council kind of as their evidentiary appeal. And that it was a firefighter, and the firefighter, for whatever reason, did ask to have it be done in open session for whatever reason. So it could happen, but it's not very common because most people don't want to have those issues be done. They usually try to keep that private. But just to point out, that's following Brown Act rules if that arises as well. Now, the role of the chair of your commission, and do I have that right? That's Commissioner Cummins. Did I catch that right as the chair currently? I hope I have that right. Okay.
Yes,
So
we do.
Yeah.
Okay, cool.
She's
Well,
taking extra notes today.
excellent. Well, good. Well, you have a special role, Chair Cummins, in this regard. And then nothing major, except that you technically are going to preside over this hearing, which means you'd administer an oath. You can receive and rule on objections. You have control over how the hearing does take place. But as I noted here, and I noted at the very outset, the good news is the city's going to provide you with a legal counsel to assist you on that. So no one's expecting you to be the master of, like, when we say objections, that's where I know if you ever watch Law and Order, objection, Your Honor, hearsay, this and that. No one's expecting you to be, oh my gosh, how do I say that? You can actually work with the attorney to advise you on what to do, and I'll talk about that later. But there's a level of control in that we do oversee how the hearing does take place. And it's really important that we follow kind of a proper procedure, which your attorney can help advise you on, to make sure that it's done in an efficient fashion, but there's also control. I don't think it's very common to see, whether it's an employee's presentation, the one appealing it, or the city's presentation, get out of hand or get unruly. But nonetheless, that's kind of the role to make sure that the hearing continues. So you're in a way, you're kind of like the judge in Law and Order, dun dun. I mean, we don't have a gavel for you, but you can kind of give a little sense of doing that there. Um, but once again, as I mentioned, you have legal counsel to help kind of guide you through that. So don't think that you're on your own if that comes up. Now, from a pre-hearing standpoint, what's not uncommon is sometimes what will happen, and this varies too, and this would also be working with your legal counsel, is it's very typical that prior to just holding the hearing, there may be some pre-hearing procedures that are taking place. And what's not uncommon is this would be for the city's representative, the employee's representative, and then it can be with the attorney, for example, who's going to represent the commission, or working with the chair, to try to find out what things do we need to do to prepare for the hearing. Are you going to let us know what what witnesses you're going to have, and there's procedures that we have to have in place as to how that comes forth. So, for example, we provide you the record, which is the notice of intent, employee's written response, final notice of discipline. That's provided to each commissioner 5 working days before the hearing. But each party is also going to provide their exhibits and witness lists 5 working days before the hearing, and they get provided to the other side as well. Part of the reason for this is to make sure that we have a process then where we know what's going to happen. We can time how the hearing is going to take place. If this is going to get done, a hearing sometimes can take. It's possible it could be completed in one day, depending on how it's scheduled, or one evening in terms of how your meeting is. It may involve multiple times, but having the ability to get this information ahead of time gives you the opportunity to plan for that, and also plan for what's taking place, and also avoid any surprises. I know when you see, we're not in a criminal court. I always use Law and Order, for example, or you could use. There's so many great court shows over the night court, whatever it is. The goal here, I was Ally McBeal's one when I was growing up. I don't know if that may date me a little bit, but what we don't want to have happen, and why you have these pre-hearing procedures, is to avoid an outcome where we have a situation that people create surprises, or I have a new witness, or this and that. We're trying to, once again, establish a framework, a set of orders, so the hearing's done a certain way, and that's kind of the goal for doing that. The part about the first one, subpoenas. Interestingly enough, technically, when you hear a subpoena, you usually think about like a superior court issuing a subpoena. That's a court order. And so, if we don't have people who are willing to, but they're relevant witnesses and they're not willing to appear, technically the commission has the authority to issue a subpoena. If the person doesn't comply with it, worst case scenario is, I guess, the commission could go to a superior court to order a judge to order the person to come. Hopefully it never gets to that point. But the idea here is we're trying our best to make sure we get the necessary and relevant people who are there to conduct the hearing in the fashion so that you can get the information you need to conduct a proper evidentiary hearing. Now, the record of the hearing. So at a minimum, the hearing would be audio taped. Either party or the commission itself can also request a court reporter. And so sometimes a court reporter is brought in. This helps create a transcript that then would get prepared by the court reporter, that creates a more solid record. But the idea is that we have a record that we can rely on, so we know what was said, what was introduced, what was not, and making sure that's done accordingly. It's also really important that so for example, if this is audio taped, that people don't talk over each other. Another area where I think for Chair Cummins, for example, to make sure only one person talks at one time, because otherwise you can create a record that we don't have that's very clear. And a court reporter would tell you the same thing. They have to be able to record who said what, and trying to make sure they can properly record that if those issues come up. But the idea here is that we have a record of the hearing that we're relying on, and that the commission would rely on to make its decision. In addition, that's going to be a record that also potentially would be relied on if we went further down the process where it went to a judicial proceeding. As I noted, that would be more of a last resort, but that would have the record that was relied upon by the commission as a result. So what's the degree of proof and the burden of proof? I always love all these fun statements we hear. Like I said, it's like we're watching Law and Order is my favorite example, just because in Law and Order, everything happens like really quickly because it's an hour-long show, right? Dun dun, and you go to the next thing and they're in court. When we talk about burden of proof, though, you hear a lot oftentimes in the criminal system, it's beyond a reasonable doubt. That is a more higher threshold that applies in criminal law. When we talk about an administrative hearing, which is what we're doing here, an evidentiary hearing regarding a disciplinary action, this isn't a criminal court. No one's going to jail. There's none of those things that are there. It's actually a lower burden of proof, and we use the term preponderance of the evidence. And preponderance of the evidence, the best way to kind of think about what does that mean? It's a more likely than not standard. Sometimes it's almost even saying that, it's if we more likely than not means that if that more than just slightly over 50% of the view of it looks like it did occur, that's preponderance of the evidence. That's not that's a lot more of an easier threshold, a lot more simpler. But is it more likely than not that the act either occurred or did not occur? Now, in terms of who has the burden of proof, I mean, who has to establish that? When we're talking about a disciplinary hearing, it goes to the city, it goes to the employer. So the city has the burden of proof to establish there was just cause, so to speak, for the for-cause action to take the imposed disciplinary action that's now being given to you on review as the Personnel Commission to determine if you're going to uphold it, modify it, or potentially you could throw it out. When we have a grievance issue, which I'll talk about towards the end of the training, that's the contractual dispute, then the burden of proof in that situation actually is on it'd be either the employer or the union who's bringing forth a grievance. So if they bring forth and say, hey, you're not following the rules, the burden of proof's on them to establish how the rule's not being followed. But on discipline, it's on us because we're the ones imposing the discipline, and it's on the city to justify that did take place. So when we have the hearing go forward and how it's kind of handled, as I mentioned, the best way to think about an evidentiary hearing, because we're producing evidence, it really is like a mini trial. And so, if we were to go to a superior court, whether it's a criminal trial or even a civil action or a civil trial, perhaps some of you have been on jury duty if you've ever had to deal with any of that. There's very, very formal rules that are followed in a courthouse or in a courtroom setting that apply. From an evidentiary hearing for an administrative hearing, it's still that same framework. It's perhaps a little bit more looser in how it's done, not as strict about objections or evidence rules, and I'll talk about that in a moment. But it's kind of that same idea. We have opening statements, presentation of evidence, a closing statement or a closing brief, and then you as the commission make the decision, just like a jury would make a verdict, or if it goes to a judge makes a ruling. So with opening statements, the party with the burden of proof, which would be the city or the department imposing the discipline, they would go first, state why they took the disciplinary action, why it was justified. The employee then potentially could also make an opening statement, or they could wait until it's their turn to do their case in chief, because the city would still be first in producing their evidence. Sometimes, normally, I think an opening statement's done orally. It could be done in writing and as a pre-hearing brief, for example, if that's something that the commission wanted to do. It is not technically considered evidence. It's more of an introduction. But the value here is noted. It is a great way to learn about the case. So it's a great way to find out, what are we talking about here? I got all this information. I got these documents to review. What's really going on here? Why are we at the situation we're at? And you get to hear those sides make that statement. Then otherwise, then it's the presentation, the evidentiary part kicks in. That's the presentation of the evidence. So for example, that we have the city that imposed the discipline presents their case in chief. They're going to go through, and we have the notice of discipline. That's going to be their documentary evidence. They may have the witnesses from the investigation who they would call to give their statements as to what took place, to which then the employee can cross-examine and question them as well. The employee can bring their evidence in their case in chief about why, for example, perhaps this discipline was too severe, or it never took place, or it all varies on what they want to address. Both sides then get to rebut each other's evidence, and the idea is to create that record in terms of how that goes. So when I say evidence, though, what are we talking about here? This comes in these kind of four main ways. The first one, stipulations. And what I will say is the goal in stipulations, these are very common in administrative hearings. Stipulations, the idea of an agreement, that this is something that both sides agree is a fact in the case. So we don't have to present it or, except to say that we've stipulated, we've agreed that this is the facts in the case. Very common that stipulations could be, that this is the investigation report. We stipulate this is the rules that were followed. things that are usually common that there's no dispute about, those are stipulations. Then oral testimony is where witnesses would come forward. And so, for example, if the city's doing their case, they call a witness who supports what happened. It could be the department head who says, yes, let's say we have a termination of person who has consistent tardiness over several years and have been disciplined multiple times. So the supervisor comes forward and says, yes, John Doe came to work all these dates at these times. He was frequently late. He was presented with several disciplinary actions, told he needed to improve. We still saw the same level of tardiness as a result. That's going to be the witness's statement on those things. Documents that are also produced can be the actual notice of discipline. It can also be evidence or exhibits that are provided depending on whatever the incident is that's supporting the cause of the disciplinary action. So, for example, if we have tardiness issues, a document that could be produced could be time cards for John Doe in that example that show that John Doe clocked in late or got to work late on these dates or several dates in that regard. And the last one, official notice, these are things that are more like official documents. And when we see this in court, this can also be done in an evidentiary hearing. Like in court, for example, you ask for official notice of a statute. Well, statute's a law. There's nothing to dispute there. So the court would say that that's the case. Here, for example, we could take official notice perhaps of our MOU agreements or personnel rules, or if there's any applicable laws that we're trying to address. That's an example of where official notice could be taken by the Personnel Commission if that request is made. And once again, when official notice is granted, that would be granted by the commission. You'd be working with your assigned attorney to make sure that's looked into when that comes up. In terms of admissibility of evidence, one thing that is different in these kind of evidentiary hearings is when we say technical rules of evidence generally do not apply, we're a little bit more open on these things. So when you do watch, as I mentioned, Law and Order, some of these TV shows, to give you an example of it, and you hear objection, speculation, objection, hearsay, these kind of legal type terms, those are based on legal rules of evidence. California actually has an evidence code. I got to spend a lot of time in law school. It's one of the things we had to study for the bar exam. And there's certain types of evidence that are admissible or not admissible depending on things. However, that's for a more formal type of action that would be in the Superior Court. For our administrative hearings, though, those rules of evidence are a lot more open-ended. And so, unless there's some evidence being presented that's not entirely relevant whatsoever, typically it's okay to have that be admissible. You can always work with your assigned attorney who's going to advise you, your legal counsel, to address that if it comes up. Where I would tell you that evidence admissibility issues and you work with your attorney on is if there's evidence that comes forward that's not within the scope of what the appeal is or entirely unrelated, you as a commission probably do have a right to say we're not going to consider that or we're not going to admit that because it's not relevant to what we're looking at here. But you should also have an idea of what those issues are ahead of time, hopefully from your pre-hearing notice of what the exhibits are, notice of what the witnesses are to address those things. The other thing about evidence, though, is that when you are taking witness testimony, other witnesses are excluded during that testimony. Part of that's because we don't want them to hear what other people are testifying to. So you're trying to maintain the impartiality of it. Now, the parties involved being for example, the employee making the disciplinary appeal. You could have perhaps it's the department head who imposed the discipline. They would be in there as part of the hearing, but other witnesses would be excluded so that there's no concern about them having their testimony impacted by those kinds of issues. As I mentioned earlier too, though, going back to Chair Cummins and the control you have as the chair, while the parties present their cases, you still have the right to control things. As noted, limiting redundant or irrelevant witnesses, or you can alter the order of witnesses. Now, you also have a right as a commission, and when witnesses come up, even though, for example, the city calls a witness, they're going to have questions. The employees, in response, may be able to use the term cross-examine. You as commissioners can also ask questions. So if you're hearing testimony and you say, hey, I'd like to hear more, you can ask a question as well. You have that ability to do that. And so that's also something that also can come up. And depending on how you choose as a commission to ask those questions, sometimes those questions may come through your chair, or the chair can delegate or say, okay, I'll look over here to Commissioner Allen. I understand you have a question, feel free to ask. However you want to handle that, and you can work with your legal counsel to address that. So once all the evidence, though, both sides make their cases, and the evidence is then presented, then we're getting towards the end. And this is where the commission then has to potentially get to the point where they're going to make their decision. So we go to closing arguments. And, once again, whether each side has a closing argument, this is actually at the commission's discretion under the rules. It can be done orally, which is each side would make another closing argument and say things. You can set a time limit for how that's done. If oral arguments are done, the party with the burden of proof goes first, opposing party goes next, and the party with the burden then can do a quick rebuttal or limited rebuttal to what the opposing party said. What I think is usually more common in a lot of these kind of evidentiary hearings, but once again, this is going to be at the discretion of what the parties agree to and what the commission agrees to, more importantly, is we see a written closing argument or a brief. That's why if you use a court reporter or a record, what may happen is you complete the hearing, then we have the court reporter put together a transcript of the hearing that gets provided to both parties. They then potentially would have a timeline that would be established by the commission to create a post-hearing, something's called a post-hearing brief, that in essence is their written closing argument. They would help you by summarizing, here's all the evidence that we saw, here's why this supports our position. Then that helps you guys take that information and then be able to make your decision once that's done. So when it comes to making that decision, then, as noted here, you as a commission overall are going to kind of work to make it be a majority rule decision, looking at these kind of two inquiries. Does the evidence show that the employee is, and I use the word guilty, maybe even a better way of saying it is that the employee, is we've established cause, or that the penalty that is sufficient as charged, and if so, is the level of discipline appropriate? So, as the employee violated the rules that have been noted, and that'd be the rules that are part of that notice of disciplinary action. And then you look at, in light of those rules being violated and the severity of it, is the level of discipline appropriate? And then the commission has the ability to sustain, reject, or when we say modify the discipline and be to a lower level to do that. Those deliberations, though, are done in closed session. So even if you have an employee who requests that the hearing be done in open session under the Brown Act, you as a commission can still have your deliberations of the decision you want to make be done in closed session, and you make those deliberations that way, which makes sense that that's a permissible use of doing that. The way it's written in your,
Gage?
yes.
So if the commission is conducting the hearing in closed session, but then they want to deliberate, then they go into closed session?
Yeah, I guess that's a good point. So
Okay.
in that situation, so let's say the hearing's done in closed session. It's not open to the public, it's in private because the employee has not requested it be done in open. Once the hearing's concluded, then you would dismiss the parties and you would hold your deliberations and continue in closed session, but not necessarily with the parties being present. Or you could go to another room.
If the commission has questions during the hearing and wants to go into closed session to discuss questions that they have with the assigned legal counsel, so they want to take a pause from being in the hearing part of the closed session and go into a private discussion with legal counsel on an issue or something that came up in the hearing, they're allowed to go into that separate closed session and then come back into the regular closed session and continue the hearing.
Correct. Yeah, so depending on the nature, that you may take breaks. There may be something where you need to confer with the attorney that, the legal counsel to sign to the commission on an issue to make a determination. You would be able to do that in closed session in private, then again with your decision being before the parties. But your deliberations on those types of issues will be done outside whether you're in I like the term closed session, however you want to say it, whether it's open or not, outside the purview of the parties that are there. So what doesn't happen is you don't, after we're done with the hearing and this, whether it's a closing argument, for example, and we decide we're going to try to make a decision that same day, you would not just sit there and say, all right, everyone, let's talk this out loud in front of everybody and make our decision. No, you would go in a private matter, do those deliberations, then come forth and make your decision. And oftentimes those decisions usually are not done verbally anyhow. They're usually done in a written decision that's issued. You'd be working with your legal counsel to help you draft that. You as the commissioner are guiding what you want, what the decision is. Your legal counsels would be helping you draft that, so it's put in a written format that creates the record of what that final decision is.
So just for the commission to know, any commissioner that has questions, concerns, wants to check in with legal counsel, et cetera. So say Marissa, you were in the hearing and were, having an issue or wanted to ask a question about something, then you could, pass a note to the chair saying, I have some questions. Could we take a break? And then can consult with the attorney that's there for all of you. So any one of you can do that.
Looking at the next, not that I'm trying to jump ahead slides,
Oh.
but looking at the slide saying that we have to, provide our findings within 15 days of the hearing. Is that business days? Is that calendar days?
I don't have that. Unfortunately, I don't have the HR rules right in front of me, and we can verify that. I will say though, while it does note 15 days, if you were to say, for example, then the parties agree to do a post-hearing brief, that's going to go beyond the 15 days. That's the stipulation, the agreement of the parties otherwise. Because it's not going to be very, it's going to take time if you had a court reporter, for example, to put a record together. And mind you, all you're doing is just waiting for that to happen. That goes to those parties, they draft it, you set a timeline, and then it would go to you at that point. So, but I don't
Yeah,
have.
I'm also thinking how much time do we have for deliberation, right, after the hearing's concluded?
And you might gather the following day and
Right.
do your deliberation. And then you would be providing collective direction to the council that's assigned to the commission regarding anything that you want their assistance drafting. So that would be the piece that you would give direction, and then a draft would come back to the commission to review before the commission would then give direction to the chair to sign off on it.
And so what probably is a more common occurrence, it's a great question. So if a post-hearing brief was done, so a written closing argument, that's not going to be done at the same time as the hearing. There's going to be a break in time, so to speak, of a matter of weeks where, or days at least, where the transcript's put together, it's presented to the parties. You guys would set a deadline that once the transcript's provided, you have to then have X number of days to provide your written argument, which could be that, and you could set a page limit or whatever it is. Then you, as the commission, would receive that written argument. You would review that, working with your legal counsel, which would probably then pertain to holding another meeting in closed session to then get back together and deliberate further as to what you want to do and direct your legal counsel on what to prepare. So it is not uncommon then as a result, even though I know, depending on the nature of the hearing, these could be things that may take multiple meetings, obviously, or over a period of time, depending on the nature of how the hearing's done and the process that you guys agree to use. Once though you make those findings regarding the discipline and what you want to do, as I mentioned, the three areas that come into play are these. Sustain the disciplinary action, which just means you uphold it. So if we have a termination and you've listened to the evidence and you feel the evidence is sufficient, there's just cause for termination. That means we sustain that. You would then provide a ruling, noting what the evidence is. You can work with your legal counsel to point out what those things are and sustain that. You have the option to decide as a commission to modify to a lower discipline. What you can't do is do a higher discipline. That's why I note the lower part. So for example, let's say that you had an unpaid suspension that was appealed to you, a 2-week unpaid suspension, and you heard all the evidence and you think, oh my gosh, this employee is horrible. They really should have been fired. Unfortunately, that's a violation of due process because they weren't fired. That's not what was imposed on them. They never had a chance to respond to that. You can't go to a higher level. Probably not too common that would happen. Just saying, if it ever did, every once in a while, clients go, well, can we go to a higher level? No, you can't. Technically the city would have to start over again, the process if they wanted to do that, and go to that. But as your authority as a commission, you don't have the authority to do that. And at the latest too, you could also just outright reject the discipline. Let's say that, there's a 2-week unpaid suspension. And during the evidentiary hearing, it comes out that, or what you feel that the supervisor had a bias towards that employee. And it turns out other employees have been doing that type of action and have not been disciplined. And you feel it's not appropriate to discipline this one employer, single them out when that's not been the practice of the city. So that could be an example of where you choose to reject the discipline. All right. That's on discipline. Real quickly before we kind of finish up here, just want to talk real briefly about grievance procedures. Oh no, hold on. What happened here? I'm sorry, I missed this one. Sorry. Post-commission procedure, excuse me. Sorry, I went too quick there. Your decision as the personnel commission, it's not the final action of the city. It is advisory to the city administrator. And the commission's decisions then filed with the employee, the department head, the city administrator. The department head of the employee can appeal to the city administrator, who then issues the final decision, which then potentially can be appealed to the city council. So if they don't agree with it, if it's not appealed, your advisory decision becomes final. Otherwise, it would go to the city administrator to issue the final decision to be addressed. And that can also go to the city council. As I noted, beyond that, there could be judicial proceedings that's done through what's called a writ of mandate to the Superior Court. Not as common an occurrence, but that's something that could also happen. The idea is, once again, there's checks and balances to make sure due process is done in accordance with proper procedures.
Gage,
All right,
can I ask you a
grievance.
question?
Yep.
So if they appeal to the city administrator who upholds or decides to proceed with the decision of the commission, and then they still appeal to the council, does council have access to the commission's decision as part of their review and of the appeal?
Yeah, normally what happens in that regard is there would not be a separate evidentiary hearing. They would just rely on the record of the hearing and the information that's there and be able to review that. That's correct. Same with the city administrator. They would have that information. They would more likely than not start off with whatever your final decision is, whatever that written decision is, and then look at the underlying situation of what else is there.
And that's
But
why
it would
there's a record created of the personnel commission
Correct.
proceeding with either a court reporter or some sort of recording that then can be transcribed. So as part of the record, that information would be accessible to the next decision maker. And they wouldn't be conducting a whole new hearing.
Starting over.
Yeah.
Correct. They would rely on the record, as would if there was a judicial proceeding. Someone appealed a writ, which I said that's usually more of a last resort. Normally, would that be a similar thing in that the court would rely on the underlying record and review that to see if there's an issue in that regard. All right. Okay, before I jump, grievance will be really quick, but discipline's the meat and potatoes, I think, what comes before you guys. Any other questions on what I covered so far? That just want to make sure you guys have had good questions so far.
Everybody good?
Everyone's like, let's get this thing going, Gage. I got you. All right. They're Gage at 6:59. I'm looking at my clock. All right. Very good. So grievances, real quick. The last few things these are the contractual things. Well, why we have a grievance is, if you ever hear the phrase breach of contract, technically people can go to a superior court. They file a civil action and say that, we have an agreement in place and it was broken. It's a breach of contract, and there's, rules, and you file a lawsuit, civil lawsuit, and it can be done that way. The reason why we have grievance procedures is this is actually our mechanism as an alternative to going to court to file a lawsuit, for us to instead have a process to resolve these things. And so we have a specified grievance procedure. Sometimes, we have a lot of different rules. Sometimes the ability of those rules to be followed to a T, we have someone who doesn't know the rule and they don't do it right. This gives a chance for us to address it. Most grievances that I've seen, at least in my career, and your grievance procedure usually has multiple steps, with the final step or towards the final step at least being going to the personnel commission. Most grievances, though, get resolved usually at the first couple steps. For example, an employee comes forward and says, hey, on Friday I ended up working 2 hours of overtime, and I looked at my time card and I got straight time. I didn't get overtime. I'm filing a grievance to get my overtime. And the supervisor looks at it and goes, oh gosh, you're right, that was miscoded. Let's fix it. That's a very informal resolution of a grievance, for example. Very common occurrence that does take place. So as noted, it allows parties to resolve disputes short of litigation in a civil superior court, curbs the Public Employment Relations Board if it's an allegation of a labor relations issue. But we define how grievances are in the human resources rules and in our city memorandums of understanding. We're looking mostly at an alleged violation, misinterpretation, or misapplication of those MOU provisions, HR rules and regulations, or other city rules. There's a number of things, though, that we exclude from grievance procedures. Complaints about wages, hours, and working conditions, Oftentimes, these things are before the jurisdiction of the Public Employment Relations Board, Labor Relations Matters, those are excluded. We exclude challenges to employee evaluations and performance reviews. If people could grieve their evaluations and employment reviews, which mind you is a subjective process, you guys would be very busy with grievances because people, it's a management right to evaluate our employees. And so they may have a right to respond to it in writing, but to grieve it, it would just, I think things would halt at the city. There wouldn't be time to do anything else. Same thing for challenges about what I would call your typical personnel type actions, reclassifications, layoffs, transfers, denial of reinstatement or denial of a step or merit increase. These are management right type issues that per our rules, we don't allow to be grieved. Disciplinary actions, we don't use the grievance procedure. We use our discipline procedures, which just went back to what we spoke about a moment ago. Challenges to violations of law or past practice, especially violations of law, it's not really appropriate for a grievance procedure to handle that. A violation of law is going to be determined by a court of law, not by, for example, the Personnel Commission or a lower level supervisor who's part of the grievance steps. And then challenges to examinations or appointments to positions. Once again, these also go to management rights. People are upset I didn't get promoted. Well, that's our management right to decide that. We don't grieve that or follow a grievance procedure for doing that. Now, the one thing here, and that's in going to the steps we talked about, the typical steps we have for those grievance procedures is these are the more, lower level ones I mentioned that oftentimes lead to resolution. The immediate supervisor, if the grievance isn't resolved, then it goes to either a higher level supervisor or the department head. If it's still not resolved, they can go to the city administrator. And then finally, it would be an appeal to the Personnel Commission that then once again is advisory to the city council for a final decision. In terms of that procedure overall, though, it is very similar. It's kind of it would be potentially like an evidentiary type hearing. Although a lot of stipulations would happen here, it's usually going to be not as more formal as a disciplinary hearing, I would think, in most circumstances. But the one difference is the employee who brings forth a grievance, or if it's a union, for example, or employee association, the bargaining unit, they would have the burden of proof. They would have to say, hey, this policy is violated and that's our grievance and you need to make us whole for whatever reason. Based on the rules, the commission has 10 days to issue its advisory findings and decision to the city council for its final decision. Once again, any of those timelines can be extended depending on the nature of how the commission handles that grievance appeal. All right, guys. I think I held it right to about an hour as we started a few minutes late. I can't tell, I can barely see Leanne's little window on Zoom here, but no, it's been my pleasure to present this to you. I hope this can at least gives you a brief overview about how that process is. And like I mentioned, the good news is, you're serving in your position as the commissioners for the city's personnel commission. You're not alone though in terms of the help of how these things will be handled if those come forward, which is a good thing. So you're providing a great civic duty and helping out the city in this regard. So it's very helpful.
Thank you.
Thank you.
Thank you. We appreciate it.
Anybody have any final questions before we let Gage go? Okay, thank you, Gage. Appreciate your time this evening.
Thanks, everyone. Have a great evening. Take care.
Okay, thank you very much.
So I think if everybody's okay, maybe we can take a 3-minute break post training and then we'll cut back for our remaining agenda items.
Sounds good. I'm going to pause the recording.
And we'll pick back up at item 5.
And it's 6:49 p.m.
Thanks. Yeah. Recruitment and employment status report.
Yes, in your packet, there is a recruitment and employment status report for the month of June. It is 3 pages in length. The first section on the first page shows you the different recruitments that we have posted right now. One piece of good news from this information is that if all of our candidates that we have in final phases of hiring process are successful, we'll only have 1 vacant police officer position that we'll need to fill. So we've made good progress there and we've been successful in identifying candidates for the position. And so we have several things that are in the works right now in the way of recruitments and some new positions that we're going to be posting for recruitment shortly. That's listed there. Then starting on the bottom of page 1 to the top of page 2, we have different recruitments that have candidates and different steps of the process. So you can see when it says on police officer, one lateral candidate and final pre-hire steps. That means they have a conditional offer. There's some final things that they're completing, and then as long as they pass those things, a final offer will be issued and they'll start work. So we have a few candidates at that phase of the process. And so that continues on to the top of page 2. And then we have some hires and promotions since our the last time that we met. So we picked up where we left off, and we have a variety of different new hires. We did a lot of hiring for summer recreation. So we hired a bunch of rec leaders that are here for the summer, some summer interns as well. And so you'll see those noted here on this section of the report, which carries on to the top of page 3. We've had a lot of hiring in the last couple months. So we have a lot of new faces and new folks performing the roles that are noted. And then the final section on the bottom of page 3 are separations. And as you guys requested at a prior meeting, for those that are retired, I put down how many years of service they had, so you would be able to see. For example, Sergeant Roccaforte retired, and with Gilroy, he had over 24 years of service. He also had time at another department, but with us, it was over 24 years. Captain Jason Smith, over 19 years. He also had time with another department before coming here. Chief Pedro Espinosa retired with over 22 years here in Gilroy, but had also worked at another department before coming here. So I noted those down so that you would have that sense of things when folks retire. They've been here a long time and have provided a lot of excellent service. So if you have any questions on the report, I'm happy to answer.
Any questions for me?
These are all of our onboardings and offboardings.
So what,
you've been busy. We've been busy. Yeah.
Right, item 6.1, new business. The job description hourly rate range for a new part-time job classification of environmental programs analyst.
Right, so we have in your packet a draft job description for environmental programs analyst, and that's why Mark Johnson, our environmental programs manager, is here this evening. We are looking to get a job description in place for a part-time analyst that would provide support to our environmental programs division in the engineering area of public works. They're here at City Hall. And there's a variety of different mandates that we're required to comply with. And so additional support is at times needed to keep up with all these different requirements. And so looking to get a part-time position in place that would be able to work on the various things that are needed in support of this program. The work is at a technical and programmatic level, compliance tracking, field inspections, outreach, enforcement, grant administration, data management. We feel this position is very similar to that of a management analyst, but it's focused on environmental programs. And it's got about 50% of the work out in the field. Some of the duties would include detailed regulatory reports, public outreach materials, managing some of our databases, conducting field audits, and coordinating with our partner agencies and service providers. This part-time position would report directly to the environmental programs manager, and will work closely with staff in different departments as well as our garbage hauler. And this will ensure that we keep up with these mandates because we have to primarily. And so this position would again be aligned with our management analyst classification and other similar analyst classifications, which for our part-time salary table formula would equate to 41.46 per hour to 53.71 per hour. And you can see in the job description that's attached the requirements that we're looking for somebody performing this level of work. So we are looking for somebody that has some experience in this area, but would have a degree that's related to the work of the position and 1 year of experience. If they had experience with the public sector in a similar kind of role, that would be ideal. So in order to put this in place and be able to hire a part-time employee for this classification and this kind of work, we need to have the job description approved because we don't have a job description. Mark, how long have you been with the city, Mark?
About almost 9 months now.
9 months now. So at some point in this last year, you all approved the environmental programs manager job description and salary range so that we could get Mark on board. And so similar, we have to approve this job description and then include this hourly rate range on our part-time exempt salary schedule so that we would have that in place. Because we need that information adopted and approved in order to then later do a recruitment. So happy to answer any questions. And if there's a technical question, Mark is here to answer that.
I guess my only question is part-time, how many hours is that?
Typically our part-time positions, we budget at 25 hours a week. So it's a little over half time. It could be up to, so it depends on what kind of funding is available for the position. If there's, funding available, we might take it up to the maximum 25 hours a week. I mean, sometimes departments want to have a full-time person, but the council is not willing to, add another position to the city's budget and make that long-term commitment to it. So sometimes they'll say, well, why don't we start off with a part-time position first, see how workload goes, and then see if there's justification to later bring back a full-time position. So that sometimes is how things kind of initiate when we're building up an area that where we're not normally accustomed to having employees. And so Mark was our first dedicated full-time environmental programs position. And now we're looking at some part-time support. We've been working in cooperation with the city of Morgan Hill. Morgan Hill has a team of environmental programs employees, and then we pay dollars to Morgan Hill, and we get so many hours of their employees working on our stuff. But we kind of reached that break point where that wasn't working and meeting all of our needs. And so we felt like we reached that point where we needed to have some of our own dedicated personnel. And so that's why council supported bringing Mark on board and getting that function identified here in the city organization where we would have the focused employee and hours. And then now we're just looking to supplement that. And we're, we've been reducing what we've been paying to Morgan Hill because we have some of our own staffing now.
When we were talking audits, are we talking literal go out and check to see what we're finding?
Yes, so
Okay.
basically for the audits, we need to make sure that everybody that has like waivers from the organics requirements will go out and we'll actually take a look at their trash, what they're throwing away to verify that they do still qualify for the waiver, that it's justifiable. And then when we get audited by the state, we have to provide proof that we've backed up those audits, that we've gone out there and inspected them. One of the things that we're preparing for right now is we will get audited by the state. It's a requirement that the state audits everybody every 4 years for this organics program. And some of my cohorts, in other municipalities have found out that right now they're down in San Luis Obispo County. So they're making their way around. So we're trying to prepare for that because it's not a matter of if, it's a matter of when, and I'm trying to provide the city in the best situation possible prior to their arrival.
So I was looking at sensor demands and I made sure that smelling was on there. So great job. There's no edits on this from me. Is there a motion on this item?
I can make a motion to approve the job description for part-time environmental program analyst and approve the hourly pay range of 41.46 through 53.71 for the classification of part-time environmental programs analyst.
I'll second that motion.
All in favor?
Aye.
Great, thank you so much. Appreciate that. Thank you, Mark.
Thank you.
Appreciate your time.
All right, item 6.2, approve reclassification of management analyst Monica Sendejas to classification of senior management analyst.
Yes, so in your packet, you have a staff report requesting the reclassification of Monica Sendejas, who is one of our management analysts. She works in the community development department. She's a direct report to Sharon Goy, our community development director. And during our fiscal year 26-27 budget process, staff did request and council approved the dollars for this reclassification. But then knowing it needs to come back here to this body for its final approval, in case there's any other details and job descriptions that need to be done. In this case, we already have a senior management analyst job description in place. And a salary range, it's all established already. And so we've just determined that over the last year, Ms. Sendejas has taken on additional higher level work of a citywide nature. And it's really the citywide impact of the work being performed that gives rise to the reclassification. We have analysts, management analysts in various departments, and their work is specific to that department. And one of the requirements to work at the senior analyst level is that you are doing things that are broader and have a broader impact on the city organization. So over this last year, Ms. Sendejas has taken on the role of team leader for our Gilroy leadership team. And this is a team of all of our managers in the city. And she stepped up to be the team leader for this group. And this was done at the request of the city administrator. This added workload requires her to organize and lead our monthly leadership team meetings. She will meet with the city administrator and or senior executive management team member to plan out and schedule each agenda, make sure these meetings are informative and effective. She identifies different topics that she feels need discussion by our leadership team. She's very approachable. And so other members of the leadership team that identify a topic needing discussion or clarification will go to her, and they trust that she'll appropriately handle their request. Sometimes there's people who don't want everyone to know that they were the one who requested that. And so Ms. Sendejas is somebody who's very confidential and trusted and will handle that appropriately. She again coordinates the topics and the speakers. So sometimes there's a topic that needs to be discussed, and it's appropriate for an outside speaker to come in to address that particular topic. And so she'll assist in making sure that conversation is facilitated and the information is provided at the meeting. And so she was identified as the best person to take on this important role and responsibility, and she's been doing a great job. In addition, she's taken on complex projects outside of her assigned department area. A recent example of this is the study she completed on options for providing aquatic services to the Gilroy community. That has absolutely nothing to do with anything that happens in the community development department. But Monica has some expertise and background in this area because she worked in the recreation field prior to shifting over to community development. It was high profile. There was a lot of interest in this by members of the public and the council. And Ms. Sendejas drew on her work experience, and she conducted extensive research and analysis, culminating with a report and presentation to City Council. And so she tackled this as part of something that has community-wide impact, because this really falls under our recreation department, but we needed her help and expertise to put this report together. So that's just one example of something that she has taken on that is outside of her normal scope of responsibilities. And then lastly, I would share, as a seasoned analyst working here at the City of Gilroy, most of the other analysts see her as the go-to person. They seek out advice and direction from her. She provides training to staff outside of her own department. She's an expert in contract administration, so often other analysts that are struggling with something will go to her to seek out advice and direction on how to tackle a particular problem. So she really is working at that higher senior level. So we see this continuing. It's been going on for the last year. It's not going away. So we feel that at this time it's appropriate to reclassify Monica Sendejas to the classification of senior management analyst effective July 1. That's the start of our budget cycle. We will appropriate place her within the senior management analyst salary range. And for reference, the senior management analyst range is the 105,631 to 145,071. And the current management analyst range is lower than that, 95,809 to 131,593. So depending on where she is in the range, we'll figure out based on our rules, the appropriate place to place her in the senior range, and then she'll have the growth potential from that point forward. These ranges that I have in the staff report might adjust because we're finishing out the outcome of labor negotiations with our Gilroy Management Association employee group. So these may adjust slightly depending on when that gets to council for approval. And the job description for senior management analyst is attached just for your reference. We're not proposing any changes to it. We just wanted you to be aware of it. And if you have any questions, I can answer them, or Sharon is here to answer any questions as well.
So for me, the only question I have is that she's been doing this work, sounds like she's been doing it for a while.
It's sort of, it's kind of that creep factor, you know,
Right.
it's like it started with, her helping with contracts. Then it became, oh, can you help lead these team meetings? And then it's, oh, well, okay, can you work on this aquatics report? So it kind of happened over time. And it wasn't until more recently that we kind of made the decision that we see this continuing. And so the reclassification is, the council supported that. So it's budgeted effective July 1, 2025.
Okay, so I guess for me, my only question is, will she receive retro
It's effective July 1, 2025. So
for the time back that
she's been getting out of class pay.
Got it.
So that's how we take care of that is when we see something that's happening on a temporary basis, we can pay out of class pay. And then until it's a position that's adopted by council and part of our position control in the budget, we can't move anybody into a position until council approves that.
Okay.
Does that make sense?
Yep.
Okay.
I have two questions.
Okay.
What future projects do you envision her potentially helping and working on? I know you guys are always kind of looking forward strategically and trying to plan ahead and be proactive. So in this new capacity, what more do you see her taking on? And then secondarily, and I don't know what you guys call it at the city, the county, we call it alternately staffing. So the positions could, you could move up without having to reclass them per se.
Mm-hmm.
Are you guys staffing them that way so that you don't always have to keep coming in for a reclass and you have built-in growth? Are you looking to do more of that? Or is this a process that works well for you and you want to kind of keep it as is?
So I'll tackle the second question and maybe I'll look to Sharon for help on the first question. So this doesn't come up that often. And so this process works for us.
Okay.
And so we do have some positions that we flex staff. So I'll use planner 1, 2, for example. We might hire somebody at a planner 1 level. But then once they get the requisite number of years of experience and they're performing well at the planner 1 level, we flex budget for it on a flex staffing basis. So once the person's eval comes up and if that justifies moving them to the planner 2, we can just do that. We don't have to come back here for a reclass. But when folks are moving into a senior level role or going into, a management level position, we typically will look to the reclass process to justify what we're doing. Because it's not a subtle difference, it's a little bit bigger of a difference in their role and what they're performing. But maybe Sharon can speak to potential projects.
Yeah, and I know the aquatics operations, that's gonna continue for a while. Because now she made a very comprehensive presentation to the council.
And I think there's gonna be a part 2.
I know, yeah, there's gonna be a part 2 for sure. So she's still, gonna collaborate with the recreation staff and there might be an RFP process and then, if an operation gets implemented, I'm sure she's gonna continue to be part of that. But also, kind of to, part of what Leanne was talking about, some other departments have had, various new analysts that started, within this past year. She kind of became like this natural person, for them to go to.
Mentor.
She and then start kind of training them. So she had brought up some ideas with me, and I haven't shared this with anybody yet, but kind of like an internal management training series that's specific to the city's systems, procedures and all these different, whether it's like finance systems and,
Yeah.
really particular.
Formalizing that a little
Yeah,
bit more
exactly.
is kind of what the need is, because sometimes when we're bringing on somebody new, we're like, okay, how are we doing this? What's going to be our plan for getting this person up to speed? And we're reinventing it every single time. But Monica has an idea of putting some sort of system in place that has some structure and materials that each time we hire somebody new, she kind of has a little mini academy that she can put them through so that they can you know,
Mhm.
learn how Gilroy does things and the different, things, because the analysts are all doing similar work, just in different departments.
Yeah. And then accessing the same systems, you know,
Mhm.
and I know when she moved from recreation to our department, while she was learning these things, she already kind of start organizing a lot of these things.
Mhm.
And now as she's training each person, I think she has to organize even better, and she had mentioned maybe making it just into more formalized and so, yeah.
Thank you. Well, then I will move forward with, making a motion to approve the reclassification of management analyst Monica Sendejas to the classification of senior management analyst.
A second.
All in favor?
Aye.
Aye.
But thank you.
Thank you, thank you, thank you.
Okay, and similar to the prior staff report, we have a second reclassification of office assistant to Zinnia Menchaca Navarro to the classification of management assistant. Again, during the budget process, this was an item that was identified within the utilities department, and so council did allow us to budget the position at the higher level. Knowing that we were gonna need to come forward and complete the reclassification process. So Zinnia has a little bit of an interesting story. She was a part of the community development department for many years and moved up from an office assistant up to a management assistant level position. And then for personal reasons, she relocated out of state and was gone for about a year. And then her circumstances changed and she moved back. And in the course of moving back, reached out and said, hey, you know, are there any jobs open at the city of Gilroy that fit in my sphere? Because we do have a reinstatement process that we have available. It's at the city's discretion if we want to reinstate somebody who worked for us. And it has to happen within a year and a half or 2 years, within 2 years of them resigning in good standing. And so we did not have, she was a management assistant in the community development department, and we didn't have a management assistant opening in any of our departments. The only administrative opening that we had at the time was an office assistant 2 position in the utilities department. So that was something that she was interested in doing to get back here working at the city. She was an excellent employee and loved working here. So she was interviewed by our utilities director and it looked like a good fit. So we brought her back onto city employment, but as an office assistant too. And so she's been back with us about 8 months. And she hit the ground running. We're establishing our new utilities department. We're still building up the positions within the department. But she has jumped right in and very naturally, you know, is completing the work that needs to be done. But Zinnia, because of her background and experience and time here at the city and her prior work at a management assistant level, it was just natural for her to jump right back in and is taking on that higher level administrative support work related to our utilities capital improvement program for both engineering and operational areas of the department. She's researching different utilities related information and she does some data collection, a little bit of light analysis work that goes with that, along with some contract administration and some smaller department projects. So clearly in the 8 months, she's showed us that she's still functioning as a management assistant. It's hard to ratchet that back when you've been working at a certain level and, you know, that's just what you do. You know, we clearly identified that and wanted to, you know, be fair and not have her continue doing work at a higher level if we weren't going to be able to reclassify her. So the department has a need, the work is there. She's very capable of doing that work and we see that kind of work continuing on into the future. It's not something that's just short term. And so we also would like to get Zinnia reclassified to management assistant. It's a position she's held previously. And so we will place her appropriately in the management assistant salary range. And you can see from the staff report, the management assistant range is currently 76,364 to 107,452. That's the July 1 range because this contract and salary schedule is already in place for July 1. And then you can see that, you know, that's a bit higher than the office assistant 2 position. So she'll be placed appropriately in that management assistant range. So we're looking to reclassify Zinnia back to being a management assistant.
Any questions or comments?
Pretty straightforward.
I'll make a motion to approve the reclassification of Zinnia Menchaca Navarro to classification of management assistant.
I will second.
All in favor?
Aye.
Aye.
Thank you.
Right.
Okay, and then we have some future personnel commission business listed in section 7 of your agenda. We're close to wrapping up the 2 senior maintenance worker job descriptions and this comes from us splitting utilities out of the public works area. And so this is, I think, the last of the split job descriptions that we need to put in place. So we will definitely have that for you at your next meeting. Council, as part of the budget process, also wants to move forward with an economic development director. They want a strong emphasis on economic development and building of revenue coming into the city. So I'm working on a job description for that position. And we have we'll look at our salary range as well for that. And then I was just talking to our interim police chief yesterday about the police department job descriptions. Captain Jason Smith started working on those before he retired. And then it kind of got put to a back burner with his retirement, but we're gonna get that dusted off and finish out some of the work on getting those job descriptions refreshed and making sure that they have all the necessary elements. We're kind of started with the sworn job descriptions and then we'll move to some of the non-sworn ones. And then as part of the budget process too, council identified and supported one of our operations services supervisor moving to being the actual title is water system superintendent. And it's just our water operation has grown and there's a lot more complexity to it and compliance and licensing and just it's mind-boggling some of the things that we have to make sure we're complying with in delivering water to our community, and it makes for a safe system, and that's absolutely vital. And so we feel that this supervisor has taken on a lot of those added responsibilities, and so we're working on that job description, and when that's ready, we'll bring that job description, salary range, and reclass recommendation forward. And then there's actually 2 job classifications that are new. Water operator, and there should have been a 7.7. There's a water quality specialist position. So again, this utilities area is really expanding and there's a lot of different things that we have to have in place. And so we're working on a job description for water operator, and we're also working on a job description for the water quality specialist. So these are, I just keep a running list of things that we're working on in our office. So that one, you have a heads up that there's things that we're doing and that you're not surprised when they come forward. And typically after we finish the budget process, there's things that I have to make sure that we're getting done and moving the recruiting process forward for the positions. So that is on the work plan. So just keep an eye on the target to get those things done. So that's all I have there, and I'm happy to answer any questions if you have any.
Thank you.
Otherwise,
No other
That's
questions? I think we can adjourn the meeting. 7:19.
yep, 7:19 p.m. Thank you very much, everybody. As I know it was a little longer meeting tonight. Appreciate your time.